So when someone calls me up and says, "Hey, I'm getting processed for an ADSEP for sexual assault, domestic violence. I was never prosecuted for it. I thought I was clear. I'm going to an ADSEP." What you have to understand is you have the most uneven playing field you can possibly imagine, where the scales are tipped extraordinarily against you. And now you're not just playing for your freedom. We're now dealing with a multi-million-dollar verdict.
All right, Tim, as usual, we're back for another episode of Off the Record. And before we were actually recording, we were talking about administrative separation boards. And I wanted to hit the record button because you were getting into some really interesting aspects of it. And the question I really have is about them are when are they used and how do they work?
Well, administrative separation boards are traditionally used if a service member commits misconduct, a lower level misconduct that's either a pattern of misconduct, think you late to formation habitually. Maybe you've disrespected a NCO or an officer habitually. That's what they're really designed to be used for, to administratively separate a service member from the military. Or if you do what's called commission of a serious offense, but a serious offense that typically doesn't warrant the level of a court martial. So it can be a lot of different things, what is considered a serious offense. But that's what they were designed to do, is something at a level that's below a court martial. So we're not talking about a criminal action necessarily, or maybe it is a criminal action, but one that doesn't warrant a criminal prosecution, where the Marine Corps, the Army, the Navy, or the Air Force, although the Marine Corps leads the way in administrative separations, unsurprising, followed closely there by the Army. The other services lag behind. It's a way for a command to separate a service member and give them still due process before their separation. That's the way they're designed, and that's what they're intended to be utilized for. But what we're seeing now is a gross misutilization of these administrative separation boards. But before I go into how we're seeing them misused, just so people understand the background of it, not everyone is entitled to an administrative separation board. You have to have served for a certain amount of time, or there needs to be certain consequences which entitle you to have a hearing before a board, or as the Marines Corps would say, would rate you a board. Number one, if you're enlisted, you have to have 6 years of service. If you have less than 6 years of service, you are likely not going to be entitled to an administrative separation board. Number two, or if the command is seeking to administratively separate you with an OTH or an other than honorable discharge. Either one or the other will entitle you to an administrative separation board. And just to be clear, there are three types of administrative separations, and there are two types of punitive separations. So everyone thinks there's only an honorable or a dishonorable. That's not true at all. At a court martial, you can get a bad conduct discharge, or the big chicken dinner, sometimes people say, at least in the Army, or a dishonorable discharge, and those are punitive. Those can only be done through a court martial. Administratively, there are three types of separations: the honorable discharge, which everyone's aware of, the general under honorable conditions discharge, which gives you a lot of the same VA rights and benefits as an honorable, although you're going to lose your right to your GI Bill or your post 9/11 GI Bill. Or the third type of discharge is called an other than honorable discharge, and the other than honorable discharge takes away the majority of your administrative rights, including likely your rights to VA disability, although there are a lot of caveats to that we can talk about in another video. But generally speaking, if the command is seeking to separate you with an OTH or an other than honorable discharge, or if you have over 6 years of service, you're going to be entitled to an administrative separation board. Okay, now what that means is if you've committed some misconduct that warrants separation, at least the command warrants separation, they're going to notify you saying what's called the basis for separation. And that could be anything from, like I said, it could be habitually late to formation. Maybe it's a drug. Maybe you popped hot for a drug test, not cocaine or methamphetamine, but maybe you popped hot for Delta 9, THC, something that is, I guess, relatively minor in the world we live in, but you still can't do in the military. Those cases are typically aren't prosecuted, but they're dealt with at an administrative separation board. So if they'll give you the notification, and either on that notification, if you have over 6 years in, you have a right to go to a board. And again, if you have a right to a board, almost without question, you should be going to a board. You should not be waiving your right to a board if you're entitled to one. Or if the command recommends an other than honorable discharge, saying the command is recommending you are discharged with an OTH, And most of the services, if you have less than 6 years in, they don't want you to have a right to a board, and so they'll recommend a general under honorable conditions discharge, so you're separated or what they call fast tracked out of the military without a board. However, our beloved Marine Corps, which you've got the Eagle, Globe, and Anchor flying behind you, they will almost always give an OTH recommendation because there's not a lot of middle ground in the Marine Corps. And so oftentimes we see service members or Marines with less than 6 years of service are entitled or rate an administrative separation board. So that's the entitlement and one is generally speaking. Before you go into how to misuse, what questions do you have about that at least initial process?
Well, the question I have is why do we consider it a privilege or what was the word that you used? It's the when you say you don't want to turn down the board. Why is it that you wouldn't want to turn down a board when you could actually go to court over something?
Well, you can't turn it down and go to court. All right. So make sure people say, well, I want to turn down my board and go to court. They're separate. It's really clear to understand that an administrative separation board is just that. It's administrative in nature. It's not criminal. And so there's no prosecutor, there's no judge, there's no evidence, there's no rule of evidence, there's no compulsory process. All of the rights and benefits and fundamental rights of due process that you're going to have at a court martial, you're not going to have an administrative board because it's administrative in nature. So you can't say, no, it's not like an Article 15 where I say I'm going to turn down my NJP and go to court martial and demand a court martial. You cannot. You can either waive your right to a board and say, and I've seen this, some people just say, get me the hell out of the Marine Corps as fast as possible. I don't care if I get an OTH or not. I want to get out as fast as possible. And
Okay.
you can waive,
So
right.
so what you're saying is if you waive your right to the board, that's what I was trying to get. If you waive your right, then they just say, okay, then you're automatically go through. We're going to fast track you out. Is
Yeah,
that
that's
what?
right. You're gone, and you're gonna get out and say, "Well, great, I'm out of the Marine Corps. Great, I'm out of the Army. I don't have to serve anymore. I'm happy." But you're
Mm,
probably gonna regret that decision because you're gonna have an other than honorable discharge on your
mm,
DD 214, or maybe a general under honorable conditions. Now, if you can get out with a general under honorable conditions, that may make sense, and you can do what's called a conditional waiver, which a lot of people don't know about, which means that I'll waive my board conditioned upon the command giving me a general under honorable conditions discharge. And that might make sense. But the majority of the time, if the command, in particular the Marine Corps, the Army is more willing, and the Air Force and the Navy, they're more willing to give conditional waivers to boards. Although I've seen it in the Marine Corps, but typically in the Marine Corps, if they say we want you out with an OTH, they don't care if they have to go through a board. They're going to go through a board because they believe it serves the order of good order and discipline.
sure.
It's
Yep.
just it's a different organization. It's a different mindset and a different mantra. And again, if you've served in the Marine Corps, if you were a Marine, you've got a son or daughter who's a Marine, you know exactly what I'm talking about. It's just the Marine Corps is different for a lot of good reasons and some reasons that can be bad.
Yeah.
But you can waive the board. But I see people routinely waiving these boards for an OTH, and they regret it down the road because you are getting kicked out with the worst characterization of discharge possible. And if you had just gone to let's say you went to an administrative separation board and lost, you're still getting an OTH. So why waive your right to a board? Even if you go to a
Mhm.
board and lose, you're not gaining anything. And what happens is people say they don't care about it. And then a year later, they go to apply to the VA because maybe their knees blown out. Maybe they have migraines or issues that happen in service, and you can still get a VA rating with an OTH, but it's significantly more challenging. And there's a lot of caveats, and it's going to make it exceptionally more difficult for you to get a VA rating. And a VA rating can be worth a lot of money. If you have a 100% rating, that's worth $4,000 a month tax free. And so you have to start thinking about that depending what your rating is. Maybe you get a 30% rating, whatever that rating is that you properly deserve. Your ability to get that with an OTH is going to be limited. Your ability to get benefits, your ability to get employment may be greatly impacted with an other than honorable discharge. So when people come to me and say they were notified of a board and they have a right to a separation board, always take that board. Unless there's a way you can get a waiver and a general makes sense in your case, go to a board and have your hearing. And the worst case scenario is you're going to get an OTH. That's what you're going to get anyways. So there's not a lot of downside. It's not as if we're going to a trial and you lose, you're going to prison. You really lose nothing by going to a board. And so I almost always recommend someone goes to a board if they have the ability to. I can kind of explain what these boards look like. And then once we go through that, I do want to I want to do more than touch on. I want to really go over what I see is a gross misuse of these boards and how the Marine Corps in particular, second in the Army, but in particular the Marine Corps, is having commands and JAGs misuse these boards to separate service members, in particular staff NCOs. And the officer side's a little bit different, but for now, at least for this conversation, I want to focus on the enlisted side. Um, Remind me to go back to that, 'cause I think it's important to understand what the board is before we understand how they're misused.
Okay. All right. That makes sense. So, in alluding to misuse of it, are are you finding in the Marine Corps or any other branch for that matter that they are, when you say misuse, are they using separation boards so that they don't have to go to a court martial in certain situations?
It's more pervasive than that. The Marine Corps is using admin set boards in cases where the evidence didn't warrant a court martial. And so here's the example that we're seeing. And I've got 3 current cases right now. 3. All Marine Corps, all staff NCOs, E7 or higher, all near retirement eligible or retirement eligible. So it all starts with OSTC, which we've talked about in length, which is the Office of the Special Trial Counsel, and sexual assault prosecutions. We all know that sexual assault prosecutions in the military are, it is, the spotlight has been placed on sexual assault prosecutions and sexual assault prevention for at least the last 20 years, as long as I've been in this business. But there have been a lot of recent changes in the last year or two. They've stood up what's called OSTC, which is the Office of the Special Trial Counsel, which in general has been a very positive thing for the military. The decision to prosecute sexual assault cases has been taken out of the hands of the chain of command, which is good because what was happening before is every allegation of sexual assault, no matter how ludicrous it was, how preposterous it was, how asinine this was on its face, was getting prosecuted because chain of commands didn't have the moral background, moral backbone, and the moral fortitude to say no, they're not going to prosecute baseless cases. They were too concerned about promotions, prosecutorial oversight, congressional oversight, that they were just sending these cases to trial and then scratching their heads wondering why there's all these acquittals. And so OSTC stood up, which is the Office of the Special Trial Counsel. And what that did is they put the decision making to prosecute sexual assault cases in the hands of prosecutors. It's like, oh, that makes sense. That's the same way it is in the DA's office or in the state office. Actual lawyers who are experienced can evaluate a case and make a determination if it's worth prosecuting, aka if it's a bogus case or not. Because if you have a real case of sexual assault, prosecute it. And let's see how this shakes out. But if you have something that's a false allegation or something that clearly can't be proven, you don't prosecute it. So OSTC has a standard. Do they have a good faith belief that they can obtain and sustain a conviction with relevant evidence and admissible evidence? And think about that. Maintain and sustain a conviction, that they have a good faith belief that if they take a case to trial, it's going to result in a conviction, and the conviction is not going to be overturned by an appellate court, which means you're not going to have a prosecutor doing something they shouldn't do at the lower level. And so what we're seeing now is a, a very good trend in prosecution. We're seeing a lot less cases of sexual assault go to a court martial. I see discretion being used appropriately. There are some very good OSTIC prosecutors, in particular in the Marine Corps, who look at a case and say, the case doesn't warrant a prosecution. We don't believe this case is valid. We don't believe we can obtain a conviction. Oftentimes these are false allegations where maybe they're not prosecuting the alleged victim, but they don't take these cases to trial. That is called a deferral, which means the OSTC defers the charges. It means they're not going to prosecute. And who does it get deferred to? It gets deferred back to the chain of command. And it's important to understand that once it's deferred to the chain of command cannot prosecute a covered offense. Remember, a covered offense is what's within the rubric or the jurisdiction of OSTC. Sexual assault, child offenses, domestic violence, those are the types of offenses that are covered offenses. So they can't touch them. So maybe if there was a sex assault allegation that involved fraternization, you have a gunny who was drinking with a PFC and they were in the same chain of command. They went out and maybe they had sex and she claimed sexual assault. Maybe there's nothing, there was evidence to show that this sexual assault never occurred, but fraternization probably did. You shouldn't have a gunny and a PFC in the same chain of command drinking together. So if that case is deferred to the command, they can give NJP. They can even do a court martial for the fraternization. Okay. But oftentimes, probably the majority of the time, these cases are deferred and there's no other collateral misconduct. They're just deferred. So what happens is you get a really pissed off chain of command because we all know that commands in the Marine Corps in particular and the Army as well can be very vindictive. We've talked about it in the past where allegations are made and you instantly go from a outstanding NCO to a shitbag overnight. And the command is pissed off. The command says, "Well, I can't believe OSTC or this lieutenant colonel or this major deferred the case. I think this actually happened. I'm sending the case to an administrative separation board." And so now what happens, instead of an administrative separation board being for what it was designed for, lower level misconduct, lower level offenses, we're seeing routinely senior NCOs, junior enlisted across the board get notified at an administrative separation for sexual assault, which if you just pause and think about that, it's kind of asinine or it's mind blowing to me where a command is saying, we're notifying you, we believe you committed sexual assault. We're taking you to an administrative separation board for sexual assault. And now you have to defend yourself from sexual assault allegations that, oh, by the way, the prosecutors did not believe occurred. Otherwise, they would have charged it. And the prosecutors have no way of stopping that because they're totally separate. Now, let me pause there and let me drive some questions to your thoughts on that and what if that seems as crazy to you as it does to me.
It does seem crazy to me because it sounds like if 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 the regular channels of being prosecuted are dropped, and then you have a vindicated uh, command that just wants you out because for personal reasons, now they're able to use this as their way to punish you for something that they most likely could not convict you of. That's what I'm
Absolutely.
hearing.
Absolutely. And not just most likely could not, they likely could not have. Because if the Office of the Special Trial Counsel, again, they have a good faith belief that they can obtain and sustain a conviction through admissible and relevant evidence, then they're going to take that case to trial. Their OSTC are typically the senior prosecutors in the military who are given wide discretion to prosecute sexual offense cases. They are not told to defer cases. When OSTC defers cases, there's a lot of paperwork that has to be generated for them to cover their own ass as to why they're deferring a case. So
Mhm,
deferrals
mhm.
aren't done lightly. I'm still replete with sexual assault prosecutions. I'm just seeing more serious ones now. What I'm not seeing is the baseless ones. Those now, where they're clearly baseless, you have a vindictive command who didn't like that decision, is sending a Marine or a soldier. I'm just not seeing this as much in the Air Force and the Navy, thankfully. It's probably coming. I'm just not seeing it. I mean, I'm seeing it across the board. It's pervasive in the Marine Corps, a little bit less so in the Army. So I'm just kind of sticking on those two. And I'm hoping it doesn't trickle down to the other services. But now they're being notified that they have to defend themselves against a sexual assault allegation at an administrative separation board where you have very limited due process rights, where you don't have the ability to subpoena witnesses, to subpoena evidence, to file motions, where hearsay is allowed, double hearsay is allowed, where sworn statements are admitted against you. So let's say, and typically the alleged victims never testify at these. They'll give a sworn, which is curated by NCIS or CID. They don't want to testify because they don't want to be cross examined. We talked about benefits earlier. A lot of people, unfortunately, scam the system and make sexual assault allegations to have sexual assault trauma in their record because under the VA, you can fairly easily rate 70, 80, 100% VA if you have some type of sexual assault trauma. There has to be some evidence of it. So if you make a sexual assault allegation and now you're seeing a therapist, there's this NCIS investigation into it. And then you say, well, I don't want to prosecute anymore. I just don't want to go through the process because number one, you know, it's bullshit and you are using this to make money. And trust me, this happens. I had a case recently we talked about later where I proved this happened. And now this alleged victim is going to get their $4,000 a month payday for the rest of their life because they have MTRS, military trauma syndrome, which is a rebuttable presumption under the VA, which should change, but that's the way it is. Now the command is sending this Marine to an administrative separation board, and I'm not even able to cross-examine the alleged victim. Their one-sided statement comes into evidence, and I'm not even allowed to cross-examine them, and I don't have the ability to subpoena witnesses. And the standard isn't beyond a reasonable doubt. The standard is preponderance of the evidence, which is 51% more likely.
That brings up now, obviously, as a Marine veteran, you're bringing back memories of how things operate, right? It's been years since I've been in, and now, so I'm putting myself in this Marine situation. So this would scare the hell out of me.
It
It would be
should.
like, okay, they're not prosecuting me. They're doing this. How in the hell do I defend against this? Especially when all these things that you're talking about, like the witnesses don't have to testify. It's based upon somebody's decision. It's not going to be in front of a jury. It's all these things. It's going
And
to be based upon.
hearsay is admissible. Think about that. Hearsay is admissible. And double hearsay, because so an agent can come in and NCIS agent can come in and testify as to what they were told by a witness or told by an alleged victim, and I have to then cross-examine the NCIS agent about what someone told them. And it's staggering that this is allowed. It was never designed for this. And I've had cases where case will go to a BOI and the government calls no witnesses. What they'll do is they'll take the NCIS investigation, just admit the evidence and not call any witnesses, and then call the chain of command in to say, "Hey, this Marine's a shitbag." No, I've had it where a chain of command will come in and say, "I'm a lieutenant colonel in the Marine Corps. I've been in for 21 years. Based on my observation of this Marine and my experience, I believe this Marine committed this offense. I believe they're guilty of it for all of these reasons. And I make a strong recommendation to the board to discharge him based on opinion." And so the cross-examination's fun, right? But it's wild what's admissible on these boards, and you have very little due process rights. And again, it's the standard is 51%. And then
So
and
so
then
how do you?
go ahead,
Oh,
go ahead.
sorry.
No, go ahead.
I was just gonna say, I mean, you're continuing to scare me. How on earth do you defend yourself against this?
Well,
I mean, let's get to the meat of the matter. That's
yeah,
really
let me
what we're.
and before we go there, I'll drop one more thing before we even get to that to scare the hell out of you even more. Now you're gonna get detailed a military counsel to represent you. Once you have notified of an administrative separation board, you rate counsel, but you don't rate the best counsel. And so what happens is, and I mean that with all seriousness. So in the military, you have to be what's called certified, qualified, and certified under 27 Bravo, which means that you have to have a certain amount of court martials and a certain amount of experience to actually practice in court. If you're not, you have to be under the supervision of a more experienced attorney. Think about this as you have a teen driver. And just my son just turned is no longer a teen driver, but was. And when he had a driver's license, he could only drive in the car with an adult with him. Okay. And I think that's like that for a lot of states. And so as a new attorney, you can only be in court with the supervision of a supervisory attorney until you're qualified and certified under 27 Bravo of the UCMJ. Well, you don't need to be qualified. You don't need to be certified to do an ad step board. And so what they do is to get new defense attorneys to get them the reps to get them to the point where they can go to court. They assign them ad set boards. And so you're typically going to get assigned, not always, and some jurisdictions are better about this, but typically you're going to get a JG, a 1LT, or you're basically going to get an O2 or a very new captain who is brand new to the game. Because if they're not doing ad set boards. There are some circumstances where you have good leadership and the senior defense counsel will detail highly qualified attorneys or more qualified attorneys to represent you. But for the most part, you're getting the brand new JAG who's brand new to defense and is trying to get certified to do court martials by doing ad set boards. And oftentimes they're doing 5, 10, 15 ad set boards. So not always, but more times than not, you're getting the newest defense counsel in that region who is just trying to get the reps to go into a court martial. So not only do you have diminished rights, but you usually have a extraordinarily junior attorney who is doing this to build his ability up. Not always, or his or her ability, but more times than not, that's what we see. So that's even more scary.
So not necessarily bottom of the barrel, but most importantly, the least experienced is what you're
You're getting
getting.
the third string quarterback, right?
Yeah. Okay.
If you're
Yep.
you're getting Kyle Trask, not Baker Mayfield. Hey,
Okay.
Kyle Trask can throw the ball, right? But there's a reason Baker's getting the reps, right?
Mhm.
And
Yep.
so they're attorneys, they're in the defense, they're in the DSO. Hey, Kyle Trask is a member of the Buccaneers. Um, but he's not throwing the ball to Evans when the game's on the line, right? He's taking the kneel when the score is 42-7 and there's 2 minutes left. He's kneeling on the ball, whereas in preseason, right? Hey, he's still a quarterback. He's still in the NFL. But you're getting Kyle Trask and not Baker Mayfield as a Buccaneers fan, right?
Makes sense. Yep.
Not always, but that's the majority of the time. And let's add one more thing before we talk about how to defend these. Let's talk about one more thing that's extraordinary. Let's say that you have 19 years. Let's say you have 20 years. Let's say you have 20, you're retirement eligible and you're in the Marine Corps. Okay. I represent an E8 retirement eligible going to an ADSET board. And in the Marine Corps, you can't just submit your retirement because you are on administrative hold pending this ADSET board. So even though you've hit your 20, you can't just walk away from it. You have to request that the administrative board be pulled and you're able to retire, but the command's going to say, sorry, not doing it. And so now you're on trial, essentially, at an administrative separation board with a brand new lawyer, no due process rights, hearsay is authorized, all things we've talked about. And if you lose, if there's a basis for separation and a discharge, I love the Marine Corps, an OTH discharge administratively reduces you to an E3 by operation of law. Not in the Army, in the Marine Corps.
Wow.
And
So you're telling me this E8 potentially could be an E3 with a stroke of a pen.
yes. And not only that, that OTH, if they get recommended for an OTH, covers their entire service period, not just their current enlistment in the Marine Corps. So they're 18, 20, 21, 23 years. They can have 3 combat deployments. They could have pulled a burning body out of Fallujah and saved, and they could have a V device. Their entire record gets marred with an OTH and they're reduced to an E3. Oh, and by the way, if you're administratively separated, you're not eligible to retire, right? So it goes, so it is a recommendation, right? So it's a recommendation that's done by the board, and it goes up to the Deputy Commandant of Manpower and Reserve. I think that's correct. MDRNA. And they make the final decision. But in the Marine Corps, I don't think I've ever seen a case where they've disagreed with with the board. Because from there, the board makes their recommendations. It goes up to the commanding general. They block off and say, yep, we agree with the board. And it goes to higher and they're out. And so now what happens is think about the value of a 21 or 20-year retirement. In particular, whether you're on blended or not, the value, I mean, you're talking $3-4 million, depending on, how much it's worth. And so, for example, if you are, think about it this way, if you are 20 years in, you started when you're 18, you're 38 years old, or you're 40 years old, and you said, I'm going to go to New York Life or MetLife, whatever it happens. I'm going to buy an annuity, which pays me $5,000 a month for the rest of my life with right of survivorship and a cost of living allowance. First off, no one would underwrite that. No one would sell you that annuity. And if they did, the discount rate would be so high, you'd be probably paying $5-6 million for that annuity. And that's not even including the healthcare and the TRICARE and all the other benefits. So what this boils down to are these ADSET boards are no longer ADSET boards. If you're retirement eligible, these are the equivalent of $3-4 million verdicts. If you lose, you are out an entire retirement and you're going to be out as an E3 if you're a Marine. If you're in the Army, you don't get that reduction. That's a Marine Corps big green weed that they give you as well. So when someone calls me up and says, hey, I'm getting processed for an ADSET for sexual assault, domestic violence, I was never prosecuted for it. I thought I was clear. I'm going to an ADSET. What you have to understand is you have the most uneven playing field you can possibly imagine, where the scales are tipped extraordinarily against you. And Now you're not just playing for your freedom. We're now dealing with a multi-million-dollar verdict where think about if you were suing a company and this is civil litigation. Well, because they say, well, 50 a preponderance of the evidence is the same standard in civil suits where money's involved. Well, if you're suing a company for a $4 million verdict, think of you can get depositions, you're getting due process, you're getting subpoenas, you're going to get a jury, you're getting experts, all things you're going to get if this was a $4 million verdict. And the lawyers are going to take 33% of it. And by the way, in that type of case, but here now we have a two, three, four, $5 million verdict on the line where you've got a second string attorney representing, not always. I mean, I have seen the defense service office do the right thing and detail more experienced counsel. I have seen that. So I don't make that blanket statement, but I've seen it the other way many, many times. In particular, if they don't request a more experienced attorney, no due process rights, and you're playing for a $3, $4 million verdict. That's what we're seeing. And I'm doing this more over and over and over. In fact, I'm flying out to Bahrain at the end of July to do a case like this. I can't talk about it yet because it's ongoing, but it's significant enough where the client's flying me all the way to Bahrain and spending a lot of money and representation and travel because they realize as well as I do that this is a $3, $4 million verdict we're fighting for. So that's the level of seriousness we take this as, and clients have to understand that that's what's at stake at these boards.
But realistically, still, after all of this explanation of what can happen to you and how and all the rights that are missing, even as an attorney, though, how are you defending? Like, not necessarily how does the gunnery sergeant defend himself, but how do you like? What's your process when you come and say, okay, listen, we don't defend the same way we did if we're going to court. We need to do it this way. How does it? What does that look like?
Yeah, and that's where the rubber meets the road. And in a lot of ways, we have to defend it in the same way we're taking on a court martial, but we have to, it's more difficult than that. And we have to obtain a lot of our own resources. So the first thing I do is I look at this as if this were going to a court martial. And I don't look at it as an ad set board saying, how do I prove this service member's innocence? Not just how do I prove that he's not guilty, because the standard isn't a government to prove their case. I need to look at this saying, well, why are we here? If OSTC deferred it, there's probably a reason they deferred it. And almost in every one of these cases, unlike a court martial, where oftentimes I'm building my case through cross examination and resting and not calling a lot of a case, we put on fairly extensive cases here. And so I need to do a lot of witness interviews. I need to interview the alleged victim. I need to go gather evidence. And what we're doing more and more and more that's been a real game changer for our law firm is we're using investigators. And so there's an investigator that I use. I'm not going to put his name out now, but he's incredibly experienced. He used to be a senior investigator for Army CIDs to run a lot of their digital forensics. And what we're doing is we're building into the fee the ability to privately retain our own investigator. Because what we're doing now is say, oh, you want to play the hearsay game? We'll play the hearsay game too. And I'll have our investigator investigate the entirety of the case, interview witnesses, take sworn statements, do digital forensics. We'll do digital forensics oftentimes on a client's phone to prove our client's innocence. And then I'll call the investigator. And that's been a game changer. So we'll call our investigator as a witness. Now, mind you, the government's not paying for this. So when a court martial, we can get funding. We're paying for this. You've got to pay the hours. And you've got to fly the investigator out because I don't have due process rights. You can request a witness be produced for an ADSET board. That's granted about 0% of the time, on average, about 0% of the time that will be granted. And if you ask for your own private investigator, about 0.0% of the time that will be granted. And so you have to fund this. And so what we're then doing is we're going to these boards and we're not just cross-examining witnesses because oftentimes they're not calling witnesses and it's total hearsay. We call witnesses, we're calling investigators. And what we'll have our investigator do is testify to his background, what he's done for a living. Then we'll have him put on evidence about number one, what OSTC is, what it means to defer a case, and why the case was deferred to begin with. So I want the memorandum showing why it was deferred to show these board members that they shouldn't even be here, that they're missing their time. So you want to basically shape this as the command is trying to screw over a service member, a staff NCO who shouldn't even be here. And what they're trying to do is kick a court martial case to a board when it shouldn't be there to begin with. So you have to educate a board to begin with. And then we'll have an investigator testify. If they've conducted witness interviews, I'll call the witnesses or I'll have them testify. And I'll build a case around my defense investigator as well as calling my own witness, and I'm presenting a case. And then
So hearsay
go ahead, go ahead.
so hearsay works both ways is what you're telling me, right?
You have to
You are able
you have to make
I'm sorry?
you have to make it work both ways. Because if
Yeah,
you don't
yeah.
play the game they're playing, you're gonna lose. Like, I hate hearsay. I think hearsay is problematic on so many levels. But if they're gonna
Mhm.
play the hearsay game, listen, trust me, I can play it better than you. You wanna play street ball? I can play street ball better than you. That I can guarantee. You wanna jump into an octagon? No problem. You want a street fight? I will play better than you can. So I will use those same rules and we will flip them to our advantage. So I'll call my defense investigator. I want to admit defense. I want to talk about records, or I need CCTV footage, or I want digital forensics. Well, you're on your own out there. I want to have digital forensics. Maybe there's text messages between my client and the alleged victim that are very helpful. I think those are ever going to get produced, or I can get those. No, I need to get my client's phone or device, pay the money, send them to a DFE. All of this is on us to do and then present it. So number one, if you don't have an attorney, first off, who understands how to play some street ball, and I mean that in all the appropriate way possible. You know, you can't play by the same rules as a court martial because the government's not playing by these rules. So you have to use the same ROE. They're shooting you, shoot back, and that's what you have to do. And you have to educate a board how bullshit these are. You really do. I'll say it again. You have to educate these board members as to how bullshit these are. And if this is sexual assault and the prosecutor or not even prosecutor, hard recorders, these JAGs had a good faith belief that our client committed sexual assault or domestic violence or child sexual assault, then why the hell are we at a court martial? Why aren't we there? The reason we're there is because there wasn't enough evidence to take it there because a prosecutor with decision making made a determination that this case doesn't warrant a court martial. That doesn't mean it warrants an ADSET board. And so it's a total misuse of these boards. So you have to educate them, and then you have to do your own investigations and have the ability to call an investigator because I can't testify, right? Think about that. I can investigate my case and I know all the flaws of it. I can argue that to a board, but they're gonna call NCIS to testify. If they don't call NCIS, they're gonna put the reports in. And so I need to be able to have the equivalent of that on our side. And unfortunately, we gotta pay for that.
This might be a rookie question, but who is the board? Like, so what if you're defending against a board that already believes that you're guilty or thinks that you're what we call the shit bag. Maybe what happens when the board wants you out? Like, what what makes this a fair fight?
That's a brilliant and insightful question, Jason, because it's not a fair fight. And oftentimes the board's hand selected to kick you out. Bottom line. And so these boards are often hand selected by the convening authority, randomly chosen, and they're predisposed to want to kick you out. So first off, the board makeup, you're going to usually have one officer. Oftentimes it's a major or a lieutenant colonel, and you're going to have one or two enlisted, and they always have to outrank you. So if you're a gunnery sergeant, you're going to have a master guns or sergeant major, someone that's going to outrank you. You can't have anyone lower in rank than you. You can have at least one, sometimes two officers. And it's real important who they are. And so as soon as I get notified of who's on my board, I have to investigate. I have to do background research on them. So I want to know everything about these three board members. So what am I doing? I'm looking them up on MOL. I want to know their background, where they've served. I'm trying to find them on social media, on LinkedIn. And this is where an investigator comes in. I'll do this myself, but I want to have I want to know everything about these three board members as I possibly can. And if I think they're biased or predisposed against my client, I have limited rights. And so we can do limited questions of members to determine if they have bias. And I can challenge them But the board member can just say, no, I'm not recusing myself. And then it goes to a legal advisor. And I put that in quotes because it's not a judge. It's usually some major who's in the reserves who's standing by via phone. They're not even in the same courtroom. No, in the Air Force, they have judge advocates in the courtroom as legal advisors. The Air Force does a phenomenally better job with due process than the Marine Corps does. Shocking, I know. But so they'll get the phone call and they'll advise them, "Hey, it's up to you. You can recuse yourself or not." And the odds of them recusing themselves are slim to none. You think a
Mhm.
Marine master going to resort
They're
say, "No, I'm
no,
biased. I'm
no,
going to recuse myself." I mean, that happens
no, no.
so
They're
percent
gonna
of the time.
they're gonna say, "I'm a professional Marine and I have integrity, and we can make the right decision here."
Not and what does that do in terms of bias? Now they're looking at you saying, "Oh, you're trying to kick me off. I'll show you." So you have to be
Hmm.
really delicate with how you do that too, right? Because you want to
Yeah.
build a relationship. You want to build rapport with these board members. So they're the ones making the decision. So you don't want to alienate them. And I see a lot of defense attorneys really alienate themselves from these board members by going in with this arrogant mindset of us against them. And you're going to lose more times than not. You want to bring them into the fold. And even if you believe they're biased against you, which oftentimes they are, the key is being a good advocate and advocating to show, hey, listen, Sergeant Major, I know you think that our Marine committed the misconduct, but let me show you how this can happen to you. Let me show you how this can happen to you. And in oral argument, whether it's opening statement or closing argument, you can talk about a situation where maybe you want to learn more about them. So you want to put them in a position where they can say, "Wow, this could happen to me too." And you want to get them really upset at the process, not upset at your client to say this is totally inappropriate that we're at this process to begin with. You want to put them in a position where they want to vindicate you and make things right. And so you have to be a very skilled advocate because you don't have a military judge to referee. There's no referee. There's no legal advisor in the room. Again, they're on standby. You're gonna have a prosecutor or they call it a recorder because it's not a prosecution, but it's essentially a prosecutor is taking on the role of a recorder, making, you know, making arguments would be patently illegal, making propensity arguments, character arguments, things that would never be allowed in a court martial, which would get you sanctioned in the court martial you're going to have. And so you need to be prepared that this is the street fight. I mean, this is like the street fight. And you need a lawyer who can do that in a way where you're not alienating the board members, but you're educating them and bring them onto your side. So ultimately, they come back and say there's no basis for the misconduct. If they say there's no basis for the misconduct, it's game over. That's the end of it. There's no basis, and they move on. So these ad set boards can be more work than a court martial, which is crazy. They can be more work than a court martial. They can, frankly, be higher stakes than a court martial because now you're talking multi-million dollar level verdicts and you have to be able to resource everything yourself. And so these can be very expensive for a client too, because they say, well, it's only an ad set board. Why does it cost this? Well, because not only are you hiring me, we need to hire an investigator and we need to have an investigator fly to Bahrain or fly to Iwakuni or Okinawa. And you need to have them testify. And we need to be fully self-sufficient. And the level of resources that are there if it's at a court martial and you need an expert, we can go to the judge and ask the judge to order funding. There's just no mechanism. And so it's a very tilted ice that you're playing hockey on a tilted rink and you're wondering why you're always losing. And so you have to understand that dynamic. But I'm telling you, Jason, we routinely win these. We win these over and over and over again. And I routinely see people lose these. And so we're doing whatever we're doing something right because we're winning these. I was so confident on one where I had a client that couldn't afford. I said, I'll take a contingent. It's non-criminal. I'm allowed to do that. I'll pay all the expenses. I'll come out of pocket the 20, 30,000 it's going to cost. I win. I'll take a contingency. I'll take a percentage of the retirement value. I was so confident I was going to do that.
Hmm.
And then they realized I'll just pay you the fee. That's probably a lot.
Yeah.
Ended up being like it took a zero off the final bill, right?
Yeah, absolutely.
So confident on, I'd do a contingent.
So you'd mentioned before that this is the ad set boards are for generally 6 years or more into your career. And then you also mentioned like E8s. What about E9s? How often do you see like a sergeant major, or like, I don't think that the sergeant major or the Marine Corps would ever face an ADSEP board, but if he did, is it even legally possible for him to face one? Because there is no enlisted higher than him, than than Sergeant Major Wes, the Sergeant Major of the Marine Corps. So
That's a great question that I don't frankly know. I don't know if the Sergeant Major of the Marine Corps face an ADSEP board, because who the hell's on the ADSEP board, right? But
right.
maybe not, who knows? Hey, let's get, hey, Pete, come on down. Hey, Pete, we need you, Pete, come on down.
Yeah,
Well,
yeah.
we can call Pete over here and he can do what he's gonna do, right?
I
No,
mean,
but you
so hypothetically, I mean, some people can go rogue. I mean, just because you are the Sergeant Major of the Marine Corps does not mean that you could get yourself into a nefarious
Yeah,
situation.
it's probably not gonna go ADSEP board because of the publicity of it. However
Yeah, yeah.
however, I've represented a division sergeant major. So
Okay.
you think that that can't happen? I represented it can happen on the officer side too. It's typically enlisted, but on the officer side, they call it a show cause board, where it's even more insidious because now you have to show cause for retention. The burden's on you, Captain Smith. Burden's on you, Colonel Jones, to show why you should be retained in the Marine Corps or the Army or whatever service you're in. And so I had a case. It was a Marine. It was an '06 getting ready to make a star, essentially a base commander who got in trouble with some text messages to subordinates, and they took him to a show cause board. You know
Mm,
who my board members were? All general officers.
yeah. Well,
2 1 stars and a 2 star. Yeah, that was a different beast altogether. And so
I
play to
bet.
know your audience, like play to you better know how to brief commanding generals or flag officers. And guess what? The captain they're gonna give you is not going to cut it. In that case,
Yeah, yeah.
they detailed him an experienced lieutenant colonel, which was great to work with. In that case,
Mhm.
we didn't get Kyle Trask. We had a very experienced '05, and we had a good result in that case. But we see that as well. And in case you have a E9, well, guess what? You're getting E9s on your panel. There's going to be more senior than you, and senior is in time of grade, not necessarily position. It's grade, time and grade. So I guess in theory, if the sergeant major of the Marine Corps, they'll try to find some Marines who are more senior than he is, not by position, but by God,
Time and grade.
yeah, I don't know on that question. I think it'd be time and grade. I don't think that would
Yeah.
ever happen, but that's an interesting hypothetical. But the reality is you may see a brigade sergeant major or a division sergeant major or a master gunnery sergeant or a senior master gunnery sergeant, and they will just find people more senior than you, and
Yeah.
they
Yeah.
will do that. And if they have to take people from outside the area, they will do that. I've seen people at a case where I had a very senior enlisted Marine in Iwakuni. They flew people up from Okinawa because they didn't have anyone in Iwakuni. There's no one in Iwakuni that could do the board. So they flew people from Okinawa, which they can do. They can bring people from outside the area too.
Yeah, it sounds like in a situation like that, it's almost more of a fair fight because they don't even know they're going to be more. I don't know. They don't know the Marine that's being charged with this,
Absolutely.
right?
Yeah, it is. It typically is. And I would much rather deal with seniors, and I'd rather have a panel of sergeant majors and master gunnery sergeants all day long because they've been there, done that. Most of them understand what the right thing to do is. Where I find problems, where I get the new major, who's the board president, who's hasn't been a field grade all that long, or
Mhm.
maybe I have an E5 and I'm getting a staff sergeant on the board. I have often is more the more I want senior experienced people who spent a lot of time in the Marine Corps. And know that's counterintuitive. A lot of people think, well, they're company men or company women, so to speak. But I don't find that to be true. I find with very senior Marines, they've been around, they've seen a lot of people get screwed over, and I
Yep.
can talk to them at their level and not talk down to them, talk to them as a peer or someone, if I was still barring a GOMAR or a court martial, I'd be a colonel, right? Barring some allegation against me, right? Who knows? But you can talk to them at your level, someone that's been around a while, and it's just advocacy, making them you don't want to alienate a jury. You don't want to alienate these board members. And I see it happen all the time. I see attorneys alienate them and get on their soapbox and rail off on the Marine Corps, rail off on the Army. And you're not doing your client any favors. You want to appeal to their interests and make it so when they go and deliberate, they feel like they're doing the right thing. And you want to get them to that point where they're maybe not as outraged as you are, but I've seen it where they are. I've
Mhm.
seen boards turn on the government where the boards are like, I've had a board say, "Why are we here? Like, why wasn't this at a court martial? Why aren't you calling the alleged victim?" I've had board members say this. I called our client to testify in a board, and one of the board members, because they're board members can ask your client questions. One of them commented that we appreciate that you're the only one here with enough integrity to testify as to what happened. We don't see the alleged victim testifying. All we have is
Mhm.
her statement. You're the only one with enough integrity to testify. And so sometimes you can flip these boards and it's a slow dynamic. It's like turning a ship. You can't do it fast. And by the end of a board, these boards can be 1, 2, 3, 4 days. These boards can be lengthy if they're complex.
Yeah.
And you can see the change. And once you see that, you're on the right, you're on the right course. And it's what it is. It's high level advocacy. Um, and we're doing this for these are multi-million dollar verdicts. So that's what people don't understand. And let's say one more thing. Let's say it's not a multi-million dollar verdict. Let's say you're a corporal and you're getting adcept, right? Well, you worked your ass off to become a corporal. I don't want to diminish that in any regard. You know, I've got a son who's about to join the Marine Corps, about to enlist in the Marine Corps. And I know how hard he's worked and his desire to join and what it's going to take for him to go through basic and AIB and go through everything he's going to have to go through. No different than if your son or daughter did that. So the fact that they aren't at the level of a sergeant major or a gunny doesn't matter. They've earned the rank and they're getting screwed over too. So even if there's not this $4 million verdict, you have your ability to continue to serve on the line. You have how many times have you seen you're leaving a Marine Corps base and you'll see the sign, keep what you've earned. I see that a lot. Leaving the base, to say, hey, don't get into DUI, keep what you've
Yep.
earned. Well,
Yes.
you have someone trying to wrongfully and unjustly take that away from you. Someone falsely accused you of sexual assault. It happens. And now you have a command that's you want to leave the Marine Corps with a DD 214 that says OTH, which means your service was other than honorable. And the justification was for sexual assault. Like,
Yeah. No. No.
maybe there's no dollar value on this. There's a fact of pride in doing what's right. And so I will take on a case like this. You're a corporal and you say, I'm getting screwed over here, and you want to fight for what's right because honor means something, integrity means something. All these core values which we preach and are indoctrinated and you learn and uphold. You look on the other side, and no one else is having these core values that you embody. Well, fight for what's right. And sometimes that means more than even the $4 million payout at the end of it, because you're doing what's right and you're defending your honor and your integrity. And that means something. And I'm just as down for that fight for the lance corporal or the corporal who wants to ensure that he defends what he's earned.
What do you say? I think I know the answer. You and I have talked about these situations extensively, but what do you say to the Marine corporal who is facing an ADSEP for, let's give a scenario for sexual assault, and they decide not to go to court martial, and they're going to ADSEP, and he feels like, yeah, I kind of did it, but she was, but realistically, I'm guilty. Um, how do you how do you get somebody to get back into the fight to protect their integrity, even if they feel like, yeah, maybe I did something wrong here?
First off, you're not guilty. Let's stop right there. You're not guilty. Office of the Special Trial Counsel made a determination on your case that was investigated by NCIS. That was maybe a command investigation. There was a lot of oversight and rank that looked at your case and made a decision not to prosecute you. That means something. That means you're not guilty. Even if you made some bad decisions along the way, you're not guilty of what they have accused you of. And now they want to take you to an administrative separation board and brand you as someone who's committed sexual assault and take away everything that you've earned. You need to fight for that. Fight for your honor, fight for your integrity, fight for what you've earned. Think about before you stood on those yellow footprints, why you wanted to join the Marine Corps. You want to serve your country. Maybe you just wanted to get out of the small town you lived in, but then you embrace the Marine Corps ethos, and you knew what it meant to be a Marine and to have that brotherhood and to have someone's back and have them have your back. But now some JAG officer or some commander wants to screw you over and not live by the same ethos you've lived up to. Stand for what's right. Stand for your own integrity, your own sense of doing what is right, even when no one's looking, and fight this. Even if you can't afford a civilian defense counsel, don't just take the easy way out. You didn't join the Marine Corps to take the easy way out. You would never have joined the Marine Corps if you wanted it easy. Fight this with everything that you have. And if your JAG lawyer isn't doing it the way they should be doing it, make sure that you are getting the proper defense. If you just want a consultation, call me. I will give you a consultation and walk you through how to do this. But don't lay over and get discouraged. You need to stand up. Go back to why you joined. Go back to what it felt like when you graduated. Go back to what it felt like when you first joined the fleet. And they want to take all of that away from you. So for the rest of your life, the rest of your career, when you meet one of your brothers to talk about he was in the Marine Corps, he's a Marine, you know what? I got kicked out with an OTH for sexual assault. Screw that. Screw that. Fight, stand up, and take a stand and fight. Because these cases can absolutely be won. We win them right and left. We win them over and over and over again, even when all of the odds are stacked against us. And why do we win? Because we're damn good at what we do and we actually care and we want to make sure that you don't get screwed over in the process. That's the bottom line.